All right, let's see. We hit the Let's Go Live button and looks like it might be working. All right, good morning. How's it going? We got some great stuff to go over today. It's gotten kind of interesting, so we've got some good stuff to go through. Apparently, they've found, I don't know, something like hundreds of thousands of emails and text messages, and that's just since September. So obviously a lot of stuff's been going on with the Olsons, but the Olsons kind of continue to delay and refuse to comply with the court. And WFG is asking the judge to step in and kind of, help them comply with some of this discovery stuff. So there's a lot happening, a lot going on. I appreciate you guys joining the channel. And, it's interesting. We started this channel kind of more as financial literacy and talking about insurance and investing and all the stuff that kind of goes on with finances. But it's turned into something different lately. I don't know if that's good or bad, but it is what it is. So I appreciate you guys being here. And if you're not familiar, if you're new, then I've got about 10 years of experience in the industry, and we're kind of talking a lot about what's going on with WFG and GFI. And it's been pretty fascinating. So we're going to go through all that stuff that's happening with Eric, and it's kind of long, so it's going to be a little bit. I'll try to break it up into some pieces later too. And real quick before we get started, I just want to do a quick shout out. Woody had became a member. He's helping out with some stuff, so that was really, really cool. Woody, I appreciate you. We've had some other members sign up, and a lot of people have asked about it. So basically, I've had to put all the documents behind a firewall. People were doing stupid stuff with it, so you do have to become a member on the channel. I apologize for that. It just kind of is what it is, and then you'll get access to the Google Drive, which will allow you to access everything. So all the documents you see here, the videos, everything else goes into all that stuff. And so I appreciate you guys for asking and reaching out. Also, if maybe you don't want to become a member, but a bunch of people are like, how can I just buy you a cup of coffee or something? In the chat, you can always do something in there as well. I think they have, I'm not familiar with a lot of this stuff, but I think there's super chats or something if you want to do something like that. But no big deal either way. I appreciate you guys just for coming in and all of the kind comments. You guys have been awesome. So anyway, what's coming up here on Monday? So there's a lot of stuff that was dropped. And part of it, I thought this was kind of funny, is Cofield. He has apparently dodged something like 16 of the summons that have been delivered to him. And if you understand what that is, that's where they come to your house and they try to deliver the paper, right? If you've ever watched a movie of somebody being summoned or subpoenaed, they come to your house and they're like, oh, you got served. So they apparently tried that 16 times with Cofield, and it has not happened yet. So they're asking the judge for help with that. Also from the Olsons, also from him, because they're not getting any of the information they need, and we'll dive into a lot of that stuff today. And then that's apparently, because they're not getting the information they need, next Wednesday, the 27th, now this will be at 10:30 a.m. Pacific Standard Time, so whatever that translates for you, they are doing a live hearing. So if you want to come on and we'll watch it together. The only thing is I cannot rebroadcast it. Clearly in the paperwork it says do not rebroadcast. So what we can do is we can do a live, watch it together and talk about it, but I'll be watching it on my phone. So unfortunately you won't be able to hear it through that. You do have to log in, but if you go to that live, I already dropped it. It shows all the instructions if you want to watch that. And that's going to be Eric and Olson basically explaining why they're not turning any over these documents and what all of their excuses are. And you'll see what those excuses are today in the filings, and they're going to be talking about that on Wednesday on kind of how to proceed, because they're not giving up any of the information that they're required from the judge to give up. And so WFG is going to be basically asking the judge, what can we do next and where do we go from here? So let's hop into it. First, let's get into kind of where we're at. And I apologize, but I did kind of want to, we've gone through a lot. So all of the documents that we've kind of gone through to this point, all of this stuff through here, all the way down into the 18th. So these were just recently dropped. These are the ones that we're going to be going through. This is going to be talking about compelling the defendant's discovery responses. So this is WFG saying, hey, we've asked for all of this information. We're not getting it. What can we do here? And then also they're going to be talking to the judge about how do we get them to speed up, because they're supposed to already have had all of these documents and it just keeps getting delayed. And then there, one we'll be talking about on Monday is going to be this ex parte application for alternate service for Dewan Cofield. And thank you guys for correcting me on his name. I was calling him Dejan or something, Dewan Cofield, because apparently he's been dodging all of their attempts to serve him. So that's where we're at. And then this one right here is going to be all the information that you need if you want to watch that live hearing on Wednesday. And again, it says right here, you're not allowed to rebroadcast or do any of that stuff, but maybe we'll hop on and watch together and talk about it, even though we'll be watching it from our own sources. So let's hop into it. This is the one we're going to be getting into today. It's going to be this motion to compel. So basically, again, what's happening is WFG got approval from the judge to be able to request information and data and all the stuff that they need, right? So they need phone records, they need emails, they need signal chats, all of that kind of stuff, and they're not getting it. Now, what's interesting is some of this communication, which we'll get to, and I should probably stop talking about and just get into it. They've got this stuff, they're just not turning it over, which is kind of interesting. So let's get into it and do my pen. Okay, cool. So again, this is going to be a motion to compel, which means they're asking the judge to step in. Can you do something about them not giving us the information that they're required to give us, but they simply just don't want to? So order compelled to defendants of Olson, both of the Olsons, in response to their written discovery, the court ordered on February. Wow, so this is all the way back on February 26th. This motion is made pursuant to the federal rules. Compulsory filed by WFG administration motion to shorten the time. So they also want to cut it down because in the original expedited discovery, they were supposed to have this in like 5 days, and they haven't gotten any of this information, so they're asking for some help on that, and this document kind of goes into why. So they're going to do a little bit of background. We'll talk about the expedited discovery, their responses, so we'll get to see exactly what the Olsons are saying and why they don't want to turn over this information. That they've attempted to meet and confer with the defendants, and they still haven't been able to get any information. That the defendants are basically putting self-imposed subject matter and certain limitations on the data, which is kind of funny when we get into that. Some of the objections that they have on why they don't want to turn over all of this information. And then also that to this point, WFG has received no documents from the defendants, and they're saying that the objections that they have should not be founded. So kind of dive through. There's a bunch of case law there, obviously. So they want to compel the defendants to be able to comply with the court's previous order directing the defendants to respond to WFG's written discovery and produce documents. The parties have met and conferred in an effort to resolve any issues relating to the court order discovery without any need for further intervention. Both parties have reached an impasse. So the two of them have been talking, and they simply cannot get this information. So the court granted them to be able to get discovery, so the court has already said that this is okay and that they can do it. And so they're basically just talking about some of the rulings as far as that goes. And so WFG has served its written discovery as approved by the court and the defendants counsel on the 28th. And they're kind of just rehashing some of the things, saying, hey, judge, remember you said that we could get this information? Because remember, the judge has got a lot of things going on, so they like to remind him of what's going on and kind of the time frames. So then on March 6th, they tried to serve them, and they evaded deficient discovery responses and did not produce a single document. Defendants refused entirely to respond to any of the 4 interrogatories, and one of the 4 RFPs served to them respect to the others, despite the court expressly finding that WFG discovery was narrowly tailored. So narrowly tailored just means that it's appropriate, right? Like if you do something in 2023, you shouldn't be able to get information from somebody from 1995, right? Like it needs to be defined within the scope of what we're actually looking for. And you can't just go through somebody's complete history. It's got to be narrowly tailored, which they did. The defendants responded that they would only produce documents subject to the unilaterally dictated limitations. To date, despite the parties' meet and conference discussions, and even in response to additional successions, so basically Successions means that they're giving up some ground. So maybe they were allowed to get all of this information, and they go, okay, well, you're right, maybe we don't need some of this and we don't need some of that, so let's kind of meet in this area. So they're kind of narrowing down the information that they're able to get. And so they're saying, hey, we've given up some ground here. We're working with these people. We're trying to get the information, but it's still not happening. So they're trying to resolve the disputes. Defendants have not produced a single document, nor have they provided any subjective response to any of the interrogatories. So here again, as a reminder of what they're asking. So interrogatory, they're asking to identify all current and former insurance agents of GFI, including the date when they first became insurance agents of GFI. And this is important, right? Because when they started also can be checked against when they left WFG. Because the issue here is not that they left. Remember, they're free to do what they want. However, you're not supposed to sit the fence and be with two companies at the same time, especially if you're moving agents and clients over. So they want to know, when did they first start with GFI, because we want to compare it to when they left to WFG. Okay, and what the defendants, the Olsons, are saying to that is, well, based on these objections, it is not relevant to the alleged breaches of contract based on the confidentiality and non-disparaging provisions, which are the only issues for which this court is considering expedited discovery and will not be provided as a response to this interrogatory. So they're saying we don't have to turn this over, because if you remember, their whole real debate or the whole legal stance that the Olsons have is that California Code 16600 says that you're not allowed to have non-competes or non-solicitation clauses, right? So they're saying since this has to do with solicitation, we're not turning that over because the California regulations should say that shouldn't even be appropriate. So we're not even talking about that. And since this has nothing to do with disparagement, right? Like a agent moving over, their time frames has nothing to do with disparaging the company or alleged breach of contract. That would only have to do with the non-solicitation. So you can see they're kind of playing on words here, right? They're like, this doesn't have anything to do with the agents because it doesn't say anything about non-disparagement, so we don't need to turn this information over. Since they kind of in their mind already ruled that what they're doing is legal, that they can take people over to this other company and they can solicit both agents and clients. They already saying, well, that's fine, so we don't need to turn information over according to that, because according to the California statute, you're not allowed to have a non-compete clause. All right, the interrogatory 2. Identify all confidential information or property that you or persons affiliated with you have retained since your departure from WFG, and identify any persons with whom you have shared such confidential information or property. So again, this is going to be things like, did you print out sheets of the top performers? Did you print out some of the leaders' bulletins so that you know who to target? Did you bring over client information? What kind of confidential information do you have? And their response is that WFG is referring to Olson's forthcoming expedited document production. So they're saying, well, it's kind of already on its way, so we're just not in a hurry to do that. Interrogatory 3, identify all communications and statements made by you or persons affiliated with you or GFI concerning WFG, its future ability to stay in business, its compensation structure, or its opportunities. Did you say anything negative about the company on your way out? And they say, well, based on these objections, Mr. Olson declines to answer this interrogatory at this time. I don't know if this is the same as pleading the fifth, but it sure feels like it does. They're like, I just don't really want to answer that at this time, so thank you very much. We're not going to give you the information you want. And then number 4 is identify any customers with whom you previously worked while engaged with an insurance agent of WFG, or whom you or anyone in your downline have communications with since you left WFG, and state the nature of the contents of each of those communications. And their response to that is, based on these same objections, Mr. Olson refers plaintiffs to any documents reflecting communications with customers that may be produced in response to the request for production. 2, that extent may or may not, they're saying to the extent that any may exist. So we're not saying that any of this exists, but if they do, you'll get it with this other request. All right, is this follows the chart written discovery? Okay. Number 1 here, all documents and communications related to the evidence of the creation of GFI, its independent contractors, its agreements, and its registration. Their response is, based on these objections, Mr. Olson will not respond to this request at this time. So we don't feel we need to turn these documents over. Number 2, all documents and communications relating to your use or profession of confidential information or property, including but not limited to WFG's compensation structure, hierarchies, contracts with providers, etc. Based on the foregoing objections, Mr. Olson will construe this request as asking him to produce documents relating to his use or possession of confidential information following his termination from WFG. Furthermore, Mr. Olson will construe that the phrase confidential information to exclude the names and contact information of WFG agents, emphasis on the original, second emphasis on added. So basically what they're saying is I don't need to turn over the information until after I got terminated. And if you can see how, I understand it's a game, right? And we're playing offense and defense here. So his defense here, I guess, is that, well, I'm not required to turn over any of the documentation prior to me leaving, which would include the starting of GFI, which would include talking to the people who came over and all of those things. He's saying, well, I only have to turn this over following the termination of WFG. So they're trying to put a line in the sand that we don't want to give information from before the termination, but we'll give you the information after the termination. WFG's gone, no, that's not what we said. We need to know what happened before as well. Number 3, all documentations and communications reflecting all statements you have made or caused to be made about WFG, its compensation, its business practices, its financial viability, its opportunities, its leadership, or its independent contractors. Are you saying negative things on your way out as we've seen through Bosley and a lot of the other testimonies? They were saying negative things and things that were inaccurate, Thawley coming over, that kind of stuff. And so his response is, based on the foregoing objections, Mr. Olson will construe that this request asked him to produce communications in which Mr. Olson reached out to WFG agents after he was terminated, and which he discussed WFG, its compensation, business practice. So again, he doesn't want to do September, October, November, December, till basically the end of January. He doesn't want to give up any of that information of all the people that he recruited then, but he said, okay, I'll give you the information after I was terminated in January. And so kind of, they're trying to split the baby on that and say, we'll give you some information, but we don't want to give you all of it. And number 4, all documentations or communications reflecting or evidencing your or persons on your behalf communicating with current WFG agents, their spouses, or their family members concerning GFI or the possibility of becoming affiliated with them. And his response is, he will construe this request as asking him to produce communications on which Olson reached out to WFG agents after he was terminated. So basically, once he was terminated, he stopped reaching out to people, right? Because once he knew kind of the lawsuit was going on, well, then that communication might be very different than all of the communication he had prior to getting caught by WFG for recruiting all of these people. So he's kind of saying, okay, well, we'll give it to you after I was terminated, but not before. So in addition to their evasive written responses, defendants have also proposed search terms for their documents, collection, and review that are likewise designed not to yield responsive information. Counsel or defendants proposed to search a list of names, including the last names of WFG insurance agents who submitted declarations both in support of opposition of the motion, and we'll see those here in a little bit, for the temporary restraining order, along with terms WFG, World Financial Group. Notably missing from those terms is any search term aid to identify communications or informations relating to GFI, the types of confidential information that defendants likely used in furtherance of their conspiracy, or anything related to their goal of destroying the quote-unquote practice company. For example, if Eric Olson emailed or exchanged text messages with anyone other than those individual entities, identities already known to this court regarding GFI, or threats regarding the loss of an insurance agent's ownership of his or her hierarchy downline, none of those communications are clearly relevant to the WFG's request for injunctive relief, would be captured by the defendant's proposal terms. So basically what they're saying here is, and we'll see the terms that they actually are giving to WFG. So again, remember they're kind of trying to find a middle ground. So WFG, of course, is going to ask for as much as possible. The defendants, the Olsons, want to give as little as possible. So what they're saying here is that Olson's team came back and said, hey, well, we don't want to search GFI, but we'll search the names of the people that you already know. So for instance, Bosley, right? Well, that doesn't really help WFG because they already know all the information from Bosley as much as Bosley has been willing to testify. So, but what they need are the people who are not listed in this yet, that they don't know of. They're trying to find out of all the people that were approached and contacted. So if they're using just those specific names, well, then of course they're not going to find all of the other people that have been contacted. And so WFG is saying, well, that's not really fair. That's not going to give us the information we need. You're trying to hide all of these other people. Why can't we search for GFI and everybody that you had a conversation about, including the word or the initials, if you want, GFI. So if we could search that, we would know everybody that you talked to. And Olson's team is saying, well, we're not going to search for GFI, but maybe we'll search for WFG, or maybe we'll search for Bosley. So they're arguing over these points. And basically what they're saying is that they will run the terms and will only follow up if there are certain terms we believe are appropriate to include. So the defense, the Olsons, are trying to say, we'll tell you what information is important for you and which ones that you can get. Beyond being compelled to serve meaningful written responses to WFG's limited discovery request, defendants should also be compelled to conduct a reasonable inquiry to identify documents and communications responsive to those requests. Defendants should not be permitted to self-servingly construct their own searches in a way that is designated to avoid discovery of responsive information. So again, they shouldn't be able to define the terms of the information that they turn over. That's not the point of discovery. As a defendant, you can't go, well, I just want to give over this information, which excludes all of the other things that you've done, right? So they're basically at odds at this point. They're asking the judge to step in. So WFG attempted to meet and confer with the defendants at no avail. During various meetings and various meet to confer conferences, defendants objected to, among other things, the time period of these, the definitions within the request and the requested information, all of which have been previously submitted and approved by the court. So they're saying, Judge, you've already said we can get all of this information and they're not giving it to us, so we need your help. The defendants declined several of WFG's requests to consider their improper, unilaterally set limitations or construction of WFG's discovery, even in response to compromises proposed by WFG. So WFG is saying, look, we've even compromised in some areas and they're still not giving us information. Defendants have even refused to state or agree that the parties are at an impasse. So this is kind of a delay tactic, right? They're kind of like, well, let's have another meeting about that. And then they have the meeting and then nothing changes. I don't know if you've ever been in a terrible relationship before, but it's kind of how it goes, right? Like, let's talk about these issues we're having. You talk and then nothing changes. And then 6 months later, you're like, okay, we need to have the talk again. And then nothing changes. That's kind of what's happening here. It's like, let's talk, nothing happens. We'll send you some more emails. Oh, well, we didn't quite understand that. Let's set another, right? It's just a delay tactic. Oh, we'll set an appointment for next week and then we can talk about this. And so they keep doing that. And GFI is basically saying, well, no, we're agreeing to everything they want. We're just having issues with these things. And so we need to talk about it some more so that we can get down to actually give you this information that we feel is appropriate. And WFG is like, no, you're supposed to give me all of it. And you're not doing any of that. So WFG here certifies that it has met and conferred with the defendant's counsel on multiple occasions, but has not been able to reach an agreement. The parties met and conferred on March 7th for a lengthy phone conference in addition to exchanges of emails and letters, and we have all of those, so we'll go through those once we're done with this. The party additionally met and conferenced on the 15th. So you can see here, it was a week of delay. Like, oh yeah, let's talk about that. And then nothing happens. Oh, we need to have another meeting. Okay. So it just keeps getting drawn out. All this information was supposed to be given within like 5 days, and now we're going on weeks of discovery and nothing's changed. The defendant's discovery responses, or the lack thereof, are additional steps to slow this litigation and delay or avoid the uncovering of their actions and misappropriate WFG confidential information in efforts to illegally and unfairly compete with WFG. Their tactics should not be continuance by the court. So court, can you step in, stop allowing them to just keep these delay tactics? The court should compel the defendants to respond to WFG's discovery request, which the court already concluded is narrowly tailored, limited, and necessary for the parties' preparation and forthcoming of evidentiary hearing. So basically they're saying, look, Judge, you've already agreed to all of these things. You didn't put any additional tailoring on that. You didn't limit it. You said what we're looking for is necessary and clearly defined, but the defendants just don't want to do it, and they keep delaying, and they won't fully respond to WFG's discovery request, so we need your help. Okay, we're going to kind of skip this. This is just a little bit of legal standard. They're going to say, look, similar things have happened in other situations before, Jensen versus BMW of North America, Apple and Y Land. And so they're just talking to the judge of like, look, these are things that have happened other times, and these are the things that happen there, so maybe you consider doing some of those things. So the argument, the defendant's self-imposed subject matter and temporal limitations are improper, which is going to kind of be a reinsertion of what they were already talking about. So they're saying that they're kind of giving the judge what they feel GFI is trying to say. So the defendants assert that the court, based on this ruling on the temporary restraining, exclude any discovery within respect to the defendant's solicitation, of any WFG insurance agent. So they're saying, well, because you lost out on the temporary restraining order, then that means we don't have to give you any of this information for the solicitation. So again, just kind of shell games playing back and forth. While the court did rule at this early injuncture, and without the benefit of discovery, that WFG has not shown likelihood of success on the merits of the violation of the non-solicitation provision, this does not equate to a blanket relevance to determine the discovery process. So basically, with a temporary restraining order, and this has become really fascinating to me on the First Amendment aspect of it, is that you have to have a very high standard of guilt to be able to give a temporary restraining order, because that limits somebody's First Amendment rights, right? And so they're saying, well, just because we didn't meet the requirement for that doesn't mean and without discovery, by the way, doesn't mean we haven't met the standard of enough evidence for this to be able to proceed and for us to get the information that we need. And so that's kind of where the two of them are hitting heads. So indeed, communications in which the defendant solicited WFG insurance agents may show that in doing so they disparaged WFG agents through false statements or misappropriated WFG's confidential information. So their argument here is, yes, we're debating about California's law and whether non-solicitation is true, but that doesn't mean that you don't get to turn over any of the information, because in your solicitation, whether that ends up being appropriate or not, you still may have disparaged and misappropriated confidential information in the attempt of getting them over. So whether solicitation falls through or not, you might have still broken the contract in other areas, and so we still need all of the information. You can't just hide behind the vagueness and the debate of the non-solicitation clause or the non-compete clause in avoidance of giving the information and the discovery that we need. So both of these provisions are central to WFG's breach of contract claim, the subject matter of which is fair game for discovery. They'll go through some more case law here. Defendants repeatedly assert on the interrogatory and the RFPs that the court's temporary restraining order excludes communication related to their conduct occurred prior to their separation from WFG. So they're disputing the time frame here, and they're saying, well, we shouldn't have to give you stuff before we were terminated. Therefore, the court ordered discovery that either had no express temporal scope or which included discovery of documents before the alleged at-issue recruiting event. So they're saying, look, Judge, you already said we could get all of this information. You didn't put any limitations on our scope. You didn't put any limitations on our timeframes. So therefore, we want all of that information. It shouldn't be up to the defendant to decide what information that they turn over. And they're going to go through some more case law here and basically talk about why that's important. Moreover, discovery to the defendant's pre-termination process and retention of WFG confidential information, the scope and ways in which they obtained that information, whether they downloaded entire customer lists. This is the one that we've been talking a lot about, right? Like, are they churning? So are they taking over customer lists? Because that's a big no-no for your license. So repositories of non-public data and their misappropriation of confidential information would be highly relevant and necessary to this court to ultimately use a preliminary injunction that would encompass the misconduct of which WFG claims. Similarly, statements made by the defendants in furtherance of this scheme to destroy their practice company are entirely relevant to WFG's request for interim injunction relief to prevent the defendants from using false, disparaging statements about WFG in furtherance of their efforts to build a competitor entity. Defendants' efforts to impose their own limitations on WFG discovery must be rejected. And then they're going to go through again and kind of talk about why these things are meritless. And, you know, we've kind of done that ad nauseum, I think. So you got to see what they were asking for, what their short form complaints were. So we're going to kind of skip through these. Again, you can have access to all this if you want it. They're talking about the importance because of the anchor leg strategy. So that's why they want information. They're redefining confidential information. This interrogatory. Yep, and they're kind of just going at length for each of one of those responses that they have. WFG has received no documentation from their defendants and their objections are misplaced. Again, they're going to go through why they refused in long form all of these things, which we read earlier. Kind of run through that. And so for all of this, this is why we're asking for your help. We want the court to compel the defendants to respond to WFG's discovery request within 2 days of this ruling and in this motion without any further objections. And so that's what that meeting is going to be for on the 27th, is they're going to meet with the judge and figure out what they can do. And the judge has a couple different remedies that he can do at this point. He can start putting fines out. He can make it very uncomfortable for them to not turn over this information. He can start ruling in their favor. So it's going to get kind of interesting. But it all seems like a big delay tactic to me. And I don't know if you guys felt that way as well. But I don't, and I keep saying this, but I don't feel that Eric really cares about the lawsuit. Right there, supposedly from the stuff that I've seen, they're at about 7,000 licensed agents. That was a week or two ago. So they're maybe getting close to 8,000 agents at this point. And so all of these delay tactics, I don't think are to win this court case. I don't know if they actually feel like they can win. It just seems like a delay tactic so that they can keep doing what it is that they're doing. And I get messages almost every other day of new people that are moving over to GFI, stuff that's happening, other people that have lost their agents. And I keep trying to get more information about what's being said. I haven't gotten a lot of it. So if a lot of you guys have been approached by these guys, please send me the information. I want to know, are they saying disparaging things or are people just deciding to leave? Because all of that really matters as far as what's going on. So let's go a little bit into some of the documents as far as the email chain. So this one's a little bit out of order. I apologize. I'm going to do my best to keep it in order as much as I possibly can, but it's kind of all over the place. So if I get a couple out of order, I apologize, but they didn't submit them in order, so I'm going to do my best to do this. And so now we can see kind of what's going on between the lawyers, right? And how all of this is taking place, and you guys can kind of, put your judgment on it. Do you think that the Olsons are just trying to delay everything and they really don't want to turn it over, or do you think they actually have a point in the information that they don't want to or shouldn't have to give up? Because that's kind of important, right? And it's interesting what technology can do now. So I don't know if you guys have been watching some of the other court cases, but the one in, I think it's Washington with Fannie and Willis. So they have these programs now that can get all the information off of your cell phone. And so this is what they're going to be talking about. So it can get not just data as far as your text messages, your emails, but what's also interesting is they have the ability to get your location. So when you're driving, you ping different towers. I didn't know any of this, so you guys might know this stuff. But so when, let's say you're driving from your house to your work, you're going to hit different cell phone towers along the way. Now, they're not necessarily tracking all of this on purpose, but they can go back and see which towers you pinged. So in that case with Fanny and Wade, they were saying that a relationship started at a certain point, right? And then they go look at this data and they're like, well, why did you go to her house 35 times the 6 months before that at 10 o'clock at night? You were at your house, and then we watched all these things ping across, and now you're at her house at 11 o'clock at night, and then you drive back home to your wife at 4 o'clock in the morning, right? Like, okay, something weird was happening there, so clearly your statement is inaccurate. So that's basically what they're going through. I don't think they're going to do that kind of data from them, but they're going to be able to get the data from who they've been talking to, what have they been saying, all that kind of stuff. And so the communication here is about the data that they've collected, and then there's some dispute on them actually turning it over. So this is going to be coming from, thank you for your time to discuss. So I believe this is from the WFG side to Olson side. So WFG is writing this, basically, the lawyers on WFG side. So they're saying, thank you for your time in discussing the status of the document collection efforts, as well as to meet and confer with your responses to the plaintiff discovery requests. Although the court ordered your clients to respond to the discovery request within 5 days, so they should have already gotten all of this information. To date, neither Mr. Olson or Mrs. Olson nor GFI have produced any documents. So this is back on the 7th? Yeah, they sent this on the 7th. So it's been weeks since then, and they still haven't gotten the information. Into the response requested, they're requesting additional time to complete their responses based on the estimated volume of data and documents that you have collected and review in order to respond to limited early discovery requests served by WFG. With respect to your collection efforts, we understand that such efforts are ongoing and that you are searching through both Sandra and Eric's phones, including GroupMe, Signal, Telegram, their personal email addresses, as well as documentations located in the iCloud and Google Drive. We also understand that counsel for Mr. Olson is undertaking a collection of Ms. Olson's and GFI's documents. We understand that at this time, given the volume of data that you are collecting, that you are unable to determine the number of documents that are likely to be produced. You offered to provide, oops, I should turn that on. You offered to provide terms and hit counts to facilitate the parties' discussions regarding the additional time you may need to complete your responses to the request, but to date, you have not yet provided the search terms that you are using or hit counts for any of the data sources that you are collecting and you're searching, other than stating you have hits for around 2,000 emails that you are currently reviewing, and we are unable to ascertain why additional time is necessary or reasonable. Your recent statements about volume of data is required and why it necessitates additional time were unexpected given Mr. Olson's prior sworn statements to the court that he was not part of GFI during this time at WFG. So apparently, Olson's sworn statement is that he was not at GFI and WFG at the same time. You guys tell me what you think about that. Do you believe that statement? And this is where it gets into semantics, right? It's like Bill Clinton was the best at this. What is your definition of a sexual relationship, right? Like, okay, so his wife is founding GFI. They're talking to agents and recruiting them over, but was he a part of GFI, right? Like, if he's not an agent with GFI, is he actually part of GFI? And that's kind of what they're saying is, Olson is saying, well, I was never part of GFI until after I got terminated with WFG. Okay, sure. Not in possession of any WFG's confidential information downloaded before his termination from WFG. Declaration of Eric Olson in opposition to WFG's motion for temporary restraining order. However, we appreciate your efforts to conduct a fulsome collection, and search for responsive materials. Secondly, we met to confer on discovery responses themselves, as we stated in our position or scope of requests of reasonable and narrowly tailored. So again, they're going through, look, we've been granted this expedited information. It's already reasonable, it's already narrowly tailored, so why aren't you turning over these documents? Despite this, you have lodged on behalf of Eric Olson 10 pages of objections to the plaintiff's 4 requests for production of documents and 10 pages of objections to the plaintiff's 4 interrogatories on behalf of Sandra, 9 pages on behalf of the 4 requests of production, and 11 pages of objections to the plaintiff for interrogatories on behalf of GFI, 13 pages of objections in response to the subpoenas. So they're just delaying everything here. Like, instead of getting the data, they're objecting to all of it, even after the judge said that they should get it and they should have it. As part of your objections, you unilaterally impose additional limitations on the scope of these discovery documents, meaning you're putting your own limitations. The judge said I should get this, and you're saying I should get this, and that's not accurate. So on behalf of each of your clients, you are imposing both temporal and subject matter limitations on what you are willing to search for and produce. As we explained, we do not think that it is appropriate here, that it is our position that choosing Eric or Sandra's termination dates as the date from which you are willing to search for or produce documents is entirely inappropriate, right? When the relationship started is very important, because if you were doing things beforehand, then that's what's important. And that's what I think the judge messed up in that other case, is he said, well, from the date that they said the relationship started is when I'm going to take this information here. I'm going to throw out everything they did before that, before when he was married, before all of these things happened, talking about that other one with Fannie and Wade. But all of that information is important to what's happening here. And GFI is saying, well, that shouldn't be important. It should just be from the date that I actually got terminated. So the Olson's unfair and unlawful practices began before Ms. Olson resigned from WFG. Yeah, exactly. So what were the things they did before they resigned? That's all going to be important to the court, and clearly well before Mr. Olson's agreement with WFG was terminated. Indeed, your clients even acknowledged that their frustrations at WFG and desire to establish a competing business was prompted, at least in part, by frustrations when WFG would not approve Mr. Olson's request to transfer his downline to Ms. Olson. As part of a concession to reach an agreement and to receive documents more promptly, we provide limiting the temporal scope of the production from September 2023 to the present. So they're saying we don't even need before that. There's probably stuff that was happening before that, and they can go back and request it if they need. But they said, let's just start with the date of September. You're right. We don't need to do all of 2023. That's probably too much information. Just give us from September to the present. Based on that same information, Mr. Olson declares, as well as the limited information that is publicly available to GFI, which makes it clear it was established in early October. So it should make sense that they're getting this information from before the termination, because stuff happened to cause the termination. Despite this offer, we understand you are unwilling to accept this proposal to further limit the scope of WFG's requests or propose a compromise of your own. You also raise specific objections to the temporal and topical scope of the interrogatory. We ask whether it would resolve your objections, at least in part, to limit this request to documentations and communications regarding WFG's future ability to stay in business, compensation structure, opportunities with WFG, dating back to 2023. So WFG is making concessions here. They're saying, okay, well, just give us the information that says about WFG staying in business and WFG's compensation structure and the opportunities. We can cut out the rest, right? We don't need happy birthday grandma. We don't need happy anniversary wife. We just want the stuff that's specific to us, and we're willing to narrow some of that down. Notwithstanding that offer, you were unwilling to agree to that modification, and you instead insisted that another meet and confer session would be necessary without offering explanation as to why. So again, oh, well, we need to talk more about this. Can we meet again and have another discussion about what exactly it is that you want? Additionally, despite our repeated requests for whether Mr. Olson, Ms. Olson, GFI intend to stand on the objections, unilateral limitations, identified responses to WFG's discovery request, you were unwilling to do so. So part of the manipulative part here is pretending like you're willing to concede some ground, right? So I come to you and I say, well, not these dates, how about these dates? And then you say, okay, that's fine, let's start with that. And then a week later, I still haven't given you what you asked for, and then I go, well, we should meet again. I think maybe instead of this, we cut it down to this. And then, well, maybe it's this. And you're going, no, that's not right. And then I go, okay, well, let me see what I can do. And then a week later, you still haven't gotten anything. Well, let me set up another meeting so that we can talk about this. And it's just to furtherance not giving up the information. So in order to move forward, we need confirmation by today. So WFG is starting to give some like harder deadlines, like we're tired of playing around. Give like, here's your deadlines. Are you willing to agree to this proposal this morning on this morning's call? So again, the funny part of GFI is they're not going, well, we're not going to give you any of this information. They're going, oh, well, maybe we could give you that. Let's talk more about it. And what WFG is saying, look, either give us the information that we've requested or say that you're not going to give it to us, so then that way we can have the court come in and step here. Don't play this middle ground of, oh, well, let me see what we can find and let's get back together. Just give us a clear definition of what you want to do. They're saying that the court order was very clear. The judge told us exactly what we could get and what you were supposed to do. You were supposed to do it within 5 days and then process witnesses within 5 days following that production. Produce witnesses in 5 days. So 10 days total. And we have repeatedly stated that we are willing to work with you because we understand the practical realities of the documenting process, but you have been unwilling to commit to a time by which you anticipate producing the documents or confirm whether you would even be willing to withdraw or modify the limitation that you have posed on GFI's request. We look forward to your response. So you can see kind of the games that are being played back and forth here. So that one was from the 7th. Now these ones are out of order. This is the 15th. So we're going to scroll down. It's kind of interesting, the information that they've been able to gather so far. So you'll see some of the numbers and let me know if you think that that's kind of strange. So this is on the 8th. Okay. Please see attached correspondence regarding this morning. So they did another meeting, another conference call regarding discovery. Thank you. We look forward to receiving your response. And here's some data that they've collected. So Eileen, I think this is GFI's people responding to WFG. So thanks for your letter and call yesterday. This one's on the 10th, or sorry, on the 8th. Yeah, and so this is going to be from GFI to WFG. So thank you for your letter and call yesterday. We explained on our call we disagree with your position about the date range, but we believe that the issue is best addressed. We obtained the concrete data and hit counts after we have uploaded the relevant materials. We also noted that it would likely take longer than an arbitrary cutoff of 5 p.m. So we're not going to be able to meet your deadline. Sorry, we got to expand that. As explained yesterday, we have been collecting their data, their documentation without any screening as to obtain the complete universe of potentially responsive matters. Our collection includes all forms of communications, including emails, texts, other types of messaging, including signal chats. We are collecting from their phones, emails, and other cloud-based storages. We have been working as quickly and as we and the vendors can collect data, right? Because they have to work with a third party to be able to do this. So here's some interesting information on what they have collected. And this is back on the 8th. So we've collected over 350,000 emails from Eric and Sandra Olson. Also 75,000 of which are dated from September to the present. Does that seem like a lot to you guys, or is it just me? So we're talking 6.5 months, right? September, October, November, December, January, February, halfway through. No, this is the beginning of March. So maybe it's more like 6 months. 75,000 emails in 6 months. That's over 10,000 per month. I don't know. You guys let me know. Does that seem like a lot to you? And then on Sandra's phone alone, we have collected 47,000 text messages for the same time period. So from September to beginning of March, 47,000 text messages. The texts from Eric's phone have not been uploaded, but we expect this phone to have similar, if not higher volume than Sandra's phone. Now, I don't know if you do a group text with 20 people in there, does that count as 20 different messages? I don't know exactly how that works. The Signal and Telegram messages have not been uploaded yet. The encryption associated with these apps has created some other delays. As we told you yesterday, Mr. Olson has a Google Drive associated with his email. That drive contains information from the operations of Pinnacle. Mr. Olson does not know how to access it personally, so he has a Google Drive he doesn't know how to access and has warranted that he won't access. So even if he could access, he's not going to. The drive consists of over 7 terabytes of data that is still in the collection process. We don't know what is on the drive, and we're working with our vendors to figure out to disable Mr. Olson's access without cutting off his ability and access to unrelated personal files on the Google Drive. Obviously, this material would be outside of the date range we believe is to be appropriate. We do not believe it is relevant, such as it is not accessed since he was wrongfully terminated. So again, they're saying, well, he hasn't accessed it since he was terminated, so we shouldn't have to give you any of that data, which I don't know how helpful that would be. 7 terabytes, that's a ton. Most computers are what, like 500 gigabytes? It's a half a terabyte. So that's like 14 computers worth of stuff that he's got on his Google Drive. I mean, I don't know. And so they're going to help meet and confer our efforts. We appreciate cooperation. In the process, though, we may disagree with some of the substance. So they're still supposedly collecting the data. Okay, so that was on the 8th in accordance with that email. And here's also what they tailored. So this one is on the 13th. So you can see they still haven't gotten any data, but they're starting to tailor some of that information. They're trying to collect everything. So thanks for your email. We have been able, this is from GFI to WFG. We have been able to complete the process of Olson's phone as well as the Signal and Telegram messages on both Mr. and Mrs. Olson's phone. This added an additional 44,000 text messages and chat messages to our collection. That's from September to March, September through February, I guess would be more accurate. 44,000 text messages on his, 47,000 text messages on hers, 75,000 emails. That, I don't know, does that seem extensive to you? That seems like a whole lot. So this is what they're proposing to start limiting some of this data. Okay, so they say, here's what we'll search for. WFG, World Financial, worldfinancialgroup.com, which who would ever send that in a text message? I don't know. That's not going to produce anything, right? And then they say, we'll look for these particular people, you know, what did they say about these people? And then maybe what they also said about these people, we'll search for those guys, that specific information, and then these guys down here as well. So anything pertaining to these people we'll add. And so with those search terms alone, it yielded more than 10,000 individual text messages, emails, and messages from other messaging apps, which our team is in the process of and reviewing. We have considered your date range proposal. We continue to view our date limitations as appropriate for at least 3 reasons. The events occurred before WFG's wrongful termination of Mr. Olson. So again, they're arguing we shouldn't have to give information over, we shouldn't have to give you this information because it was before the end of January when he actually got terminated. So for number 1, encrypted information. Where's number 2? First of all, is wrongfully or not conducted. WFG is seeking its merits and discovery. Oh, second, such discovery is not appropriate in the light of the court's order. We identify the basis for expedited discovery and its use of encrypted messaging service to rapidly unfold events, including the conference in early March. Those concerns are addressed by our collection, preservation, and production of encrypted messages, and the fact that the conference is in Hawaii and ongoing will have been ended before the respective motions. So again, they're just kind of arguing with what's going on. And it's kind of funny here, I think this last one. Third, in addition to falling outside of the scope of what should be allowed as expedited discovery, WFG's proposed date cutoff would impose a significant burden beyond what we are already incurring in providing the exhaustive expedited discovery set forth. So if you make us actually give you all the documents you want, it's going to add roughly 50% more work to us. And, that's just really not fair. I'm sorry, that's funny to me. I probably shouldn't laugh. We are more than willing to meet and confer tomorrow or Thursday. Let's set up another meeting to talk about this. In the meantime, we will continue to make progress and review our intention to make our production this week, right? Keep putting it off. All right, so then on the 14th, thank you. Here's another time. Let's set up another conference call on the 14th. We've stated we'd be happy to meet and confer. We want to connect the timing of these things. Are you available at this? So they're just kind of scheduling. Oh, separately, a few days ago, we sent out an email trying to connect for depots for WFG agents, copying you on those, but we have not heard back from Gordon or Reese. I don't know who either of these guys are, if you guys know who Gordon or Reese are. We would like to discuss that tomorrow. Two, I assume you have been in communication with them. It would be great if you could get them involved and get that done as well. Because I think that was something that Olson was asking for. Unfortunately, we have a conflict at this time. Can we do another time? Okay, let's do 12:30. This is on the 15th. Okay, and we finished that section of emails. This is on the 15th. Thank you for your call earlier this afternoon. We write to follow up and summarize our meeting. We stated our previous letter dated on the 17th. They're kind of like making notes for all this stuff, so when they turn it over to the judge, that they're gonna have some relevance here. Like, look, we've worked with these guys, we've tried, they keep pushing us off, but none of them have produced any documents in response to this request. You have provided us with an update of your search productions, which we appreciate. However, we still have not been provided a concrete time frame. So GFI keeps saying, yeah, we're working on these things, we'll get it to you eventually, and then weeks go by and nothing's happening. So with respect to your search terms, we provided a list of updated terms that we would like. We understand your concern regarding GFI, as you think it may be overly burdensome, seeing that the term is used in at least one of the email addresses. So that could be kind of annoying, right? Because if GFI is in the email, so note if you don't want discovery, do your name at the company, whatever, at gmail.com or whatever, so that way it adds every single email you sent out, even the ones to grandma to say happy birthday, now get pulled up in this list of emails. So a way to avoid discovery there if you want to do that. With request to and I'm joking, by the way, okay? With respect to unilateral temporal limitations the defendant imposed in their discovery responses, we understand that we have reached an impasse. So we're not making any headway on this. We'll be seeking judicial intervention accordingly. So we're going to reach out to the judge and see if we can get some help, because you're not really helping us with that. So with respect to limitations on confidential information and responses to these things, you first stated that you were not, in fact, applying the limitation you identified and instead construed your own understanding of confidential information more broadly. However, you proceeded to state that you were applying your own interpretation of what constitutes confidential information. So they're making up their own definitions for things. According to this person, with respect to your request to further clarification regarding the scope of WFG's interrogatories, Mr. Olson, we clarified today that we are indeed seeking any communications that Ms. Olson had with customers regarding business or transfer of the business to GFI, right? This is important because this becomes churning. So did they go back to all of their clients and move them over into new policy? Now you can add stuff, that's perfectly fine, but to purposefully get them to cancel a policy and start a new policy, the client takes thousands of dollars in loss in that, in annuities and in permanent insurance policies. So that's bad for the clients. And this includes communication that Ms. Olson may have had with friends or family members. Yeah, so a lot of clients, we work with a lot of warm market in our industry, right? So that would include I have a lot of friends and family members who are clients of mine. And so she initiated life insurance policies with them, including her mom. So apparently her mom has a life insurance policy with her. My mom does as well. We are not interested nor seeking communications relating to purely personal matters. So yeah, you're right. We don't need the happy birthday, the happy Mother's Day, that kind of stuff. We don't need any of that. Merry Christmas. However, any communications with friends and family regarding Ms. Olson's business are still important. They're absolutely relevant to the current purposes of this litigation and must be produced. And GFI is saying, well, we can't give you all that information. And in the things that they defined, those key words that they want to use, you might not get something like that. You might not get those text messages in those particular requirements. Or those particular guidelines that GFI is trying to assess on the production of information. We are similarly seeking communications regarding business or the transfer of business for anyone in Olson's hierarchy to the extent that Ms. Olson is aware of such communications or possesses such communications in her custody and control. We do not expect her to solicit communication or documents from her agents in her hierarchy that she is not aware of or does not have in her custody or control. We understand that you will discuss this clarification with your client. So part of what they were saying on why they don't want to turn over these documents, they go, well, it's not fair. You can't ask the Olsons to go ask everybody else for their documentation because it's in regards to the people that are close to them. And they're saying, well, that's not what we're asking for. We just want the communication that whatever she has. So if there's something between her and she sent a text message to this person, we should still be able to get that. We don't expect you to go get it from them. Just whatever's in your possession is what we want. And so we appreciate you discussing that clarification with your client. With respect to a protective order, we stated that we will agree to a protective order to the extent that it does not substantially stray from the model forms of the North District of California. We similarly stated that we will require the protective order to encapsulate existing or potential future related litigations, such as we can utilize any documents or communications to produce this litigation without having to repeat the discovery process or reproduce documents in each individual action. We really will agree to maintain any confidential or highly confidential designations preceded in this litigation in relevant litigations, and we have provided WFG's proposal to the draft protective order. So protective order, now they're trying to do additional documentation to say, well, we want to be even more limited on the information that we can get that WFG can get. We're going to all do protective orders, which I think they have filed at this point, to limit that information as well. So once you have had a chance to review, please let us know in further conference as necessary. So, okay, we'll do a protective order. And this could be kind of important, right? Because what if there's a social security number in there, or there's, I don't know, some kind of private information that they don't want to get out to the public. So WFG, again, is kind of conceding on this. They're saying, okay, as long as it doesn't limit our discovery, we will put a protective order on it that if there's anything in there that's confidential or highly confidential that's produced related to this litigation, kind of think of, it's not quite classified documents, but kind of gets into that category of, okay, we'll be more sensitive with these things. But the question is, are they actually sensitive information, or are they just trying to elude giving information even further? So you stated that you will not produce any documents until the protective order is in place, and stated that this is a gating issue. So again, this is the 15th. So now this is what, 10 days after they were supposed to produce this information. Now they're talking about a protective order. So it's been a week and a half. The discovery should be done at this point. And they're going, well, we think we need a protective order, and so we're not going to produce any documents now. Now that we've defined these things, now that we've limited the scope, now that we've done all those things, well, now that we think about it, we probably need a protective order, and we're going to do that first, right? So it's just delaying everything. So in regards to WFG's response to the defendant's discovery requests, which we are providing voluntarily, despite the fact that you have not requested leave or take early discovery, and the court has not authorized you to take early discovery in this matter, we confirm that we have drafted WFG's responses and are awaiting approval for the clients. Once the clients approves these responses, we will serve them on defendants. We anticipate that you will have these responses early next week. Finally, in regards to, I don't know if you guys know who these are, Jordan Altura or Gordon Reese. Are these WFG people maybe? I don't know, maybe part of the company. Because I think, excuse me, Olson asked for discovery around his temporary restraining order. So I don't know if those people are involved in that. If you know who that is, put it in the chat, please. We are aware that he has attempted to contact the third-party witnesses you have subpoenaed, and I've since responded to your email requesting a call discussing deposition scheduling. If any is scheduled, we would be happy to join. We look forward to receiving prompt response, and we hope to minimize the issues for which you seek judicial intervention. This was written by Ellen. All right, I think we're almost through it. So here's is this WFG's too? Yep. So this is WFG's proposal. They're saying, hey, we also need to add in these terms. If we're going to start limiting some of this stuff, we need to add in these terms as well, because that would be important to us. Thank you for this email. We're able to complete the processing. This added over, and this one, I think, this one might have been part of that first one. Added another 44. Oh, no, this is another one, right? This is from the 13th. When was this one? 15th. Okay, these are out of order. Again, apologize about that. But apparently those added another 44,000 emails or text messages included in that. And then this is a copy of the first one we just read. Exhibition M. This is on the 16th. Okay, so this is a new one we haven't gotten to yet. Thanks for your call again yesterday. However, we ensure our correspondence accurately reflects our call. First, regarding the timing of our production. So this is from GFI to WFG. Regarding the timing of our production, we were ready to produce documents yesterday as we said we would. Any delay is not due to a lack of diligence on our end. We flagged in our initial call due to the personally identified information potentially would help if I didn't cross everything out, right? Competitive sensitive information that our client is seeking, and the real risk of retaliation against our clients and others. We need to have a protective order in place before we can produce documents. So again, we were ready to give you everything, but now we realize that we need a protective order. And so we provided edits to the proposal to the order on the 7th. We have heard nothing from your client until roughly 6 p.m. last night. So we gave you some ideas on the proposal for that protective order on the 7th. It's now the 15th, and we still haven't heard anything on that. So you still haven't filed it. You also said WFG wanted us to run additional search terms. We said we would be glad to, but we were unprepared to say that those search terms would, until again roughly 6 o'clock last night. We will review your edits sent on the protective order and get back to you shortly. Secondly, with respect to your purported concerns with the confidential information, this does not accurately reflect our position. We still do not believe that we should have to turn this over to you. We disagree with that such information is confidential and in any legal sense, but have not restricted our review to our understanding or any recognized legal definition of confidential. Third, regarding your position of WFG's response to our discovery request are voluntary, we strongly disagree. Your client agreed to provide reciprocal discovery to avoid motion practice, asking the court to provide us the right to seek such discovery. That does not make your discovery response voluntary or optional in any sense. And to that end, we had understood that WFG would be providing responses to our discovery requests last week. But we learned on Friday that rather than abide by the 5-day timeline by which we proposed requests, WFG will get us responses early next week. We look forward to receiving your discovery responses. Fourth, please provide dates for these witnesses' production prior to the production. Fifth, as for communication with these people, as you know, they have not requested a call. Rather, they have refused any such call. So maybe both sides are kind of playing around here. We will follow up with them directly, but we keep we keep you copied. We would appreciate if you would do the same with your third-party discovery requests and scheduling. In that regard, it appears that WFG unilaterally scheduled a deposition for Mr. Valle without coordinating with us, required by the law. We will try to confirm that date with our team, including Ms. Olson's counsel. If it turns out that the date does not work, we will need to select an alternative date. So it sounds like WFG finally set a time with Mr. Valle to do his, but they haven't let them GFI know yet. So GFI is going to say, okay, well, we'll look in our calendar and we'll see if that works for us, and maybe it does, maybe it doesn't. Finally, thank you for sending the proposal of the search terms. We agreed to run the terms and follow up there if there are any believe are appropriate to include. And that's the end. So those are all the newest documents that have kind of been produced around all this stuff. So I don't know, you guys tell me, does it seem like everybody's just playing games here and we're not actually moving the ball forward? And I don't know, should WFG turn over information if GFI is not doing it? I don't know. It's supposed to be kind of a reciprocal thing. Either way, it sounds like they're at a standstill. And so now they're going to be talking to the judge, which is going to be happening again on the 27th. So if you want to join us for that, we're going to be doing that again. We cannot broadcast it. We cannot rebroadcast it, but we'll see if we can watch it live. Maybe we'll talk about some of the stuff that's going on. We'll just have to watch it on our phone separately and kind of see what's going on. Why are they at an impasse, and what is the judge going to do from that standpoint? So hope that was helpful for you guys. I appreciate you. And again, on Monday, we're going to be talking about what's going on with Cofield. His is fairly long as well. Apparently, he's been dodging all of these requests to serve him. So we'll see what's going on there. Hope that was helpful for you guys. I appreciate you. Catch you later. Bye.